Everyone. So this video is on the Brown versus Board of Education case. Brown versus Board of Education of Topeka challenged the separate but equal doctrine that had been applied to public elementary and high schools, kind of in mainly the South region, but kind of across the United States. It resulted in a unanimous decision that reversed the prior decision that stated that separate but equal was just and constitutional. That decision was made in Plessy versus Ferguson in 1886. So you can already see the 1886 compared to 1950, mid 1950s, a little bit outdated. And so already there was, I feel like at that time it was time for change. It was time for something new, something a little bit more updated. And so the Supreme Court found that separate but equal violated the Equal Protection Clause of the 14th Amendment of the Constitution in regard to the decision. Chief Justice Earl Warren stated, quote, "Today, education perhaps is the most important function of state and local governments. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate education facilities are inherently unequal." And so kind of people who backed the Plessy versus Ferguson case said that, these schools are separate but they're equal. The facilities are equal. The kind of the quality of teaching is equal, all that sort of thing. And so the Supreme Court really decided against that, saying that the African American schools were really kind of lacking in words to the white public schools. So just kind of some background about the case. In 1951, a class action lawsuit was filed against the Board of Education of the city of Topeka, Kansas. The plaintiffs were 13 Topeka parents on behalf of their 20 children. The suit called for the school district to reverse its policy of racial segregation. The Topeka Board of Education operated separate elementary schools under a 1879 Kansas law, which permitted districts to have separate elementary schools for black and white children. Prior to the Brown versus Board of Education, there were 17 states that required the segregation of public schools, and additionally there were 4 others that had optional or limited segregation in their public school systems. So going on to question 2, what is the central question that the Brown Court indicates must be answered? Kind of going into that, the equal protection, 14th Amendment, that sort of thing. So that's kind of where I'm headed next. So Brown versus Board of Education was trying to figure out if these segregated schools were really equal, because, again, of the precedent that had been set with the Plessy versus Ferguson. The Equal Protection Clause of the 14th Amendment provides that a state can't deny any person within its jurisdiction the equal protection of the laws. This clause expressly applies to state and local government action, but the Supreme Court has held that it also applies to federal government action as well. The Supreme Court said that special attention, or during the case, they paid special attention to the Equal Protection Clause applied to this case, and whether that clause prohibited the person or the operation, of separate public schools for whites and blacks. The Supreme Court also felt it was very important to issue this decision unanimously. Although the legal effect wouldn't have changed, they felt that people who were in support of the segregation of public schools, they could kind of gain some momentum that, hey, the Supreme Court didn't even unanimously decide this case, that some of the Supreme Court justices are in favor of segregation and that sort of thing. So they felt it was very important to decide unanimously on this decision. Going into number 3, what was the effects of segregation in public education at the time of this ruling? So obviously not everyone welcomed this decision, especially in the South. That's kind of where Jim Crow really had its grip, and a lot of people did not like this verdict, and so some schools were shut down instead of desegregating. In Arkansas, Governor Orville Faubus, I think that's how you say his name, called his National Guard to block black students' entry into Little Rock High School. So you can see that people really didn't take this lightly. They felt very strongly about it, and a lot of people were willing to go to great lengths to stop this from happening. So in response to schools not desegregating, the Supreme Court delegated the task of carrying out school desegregation to district courts in order that they occur, quote, with all deliberate speed. The first wave of black students to attend formerly all-white public schools faced extreme backlash from white individuals from the community whose kids also attended that school. And then something that white people kind of used to get around this was that white students around the country were given assistance to attend white-only private academies that were taught by teachers who formerly worked at public schools. And so that was kind of a way that some white people got around this, who were adamant that their kids weren't going to go to a school with black children, which is kind of sad. And lastly, going into the fourth question, what harms do you believe would result if an employer were allowed to require its employees to work in facilities that were segregated? Kind of my response to this: if workplace facilities were segregated, I think you would see this kind of the same thing that happened with the public schools. The environment for one race would be much better than the facility for other races. I don't think the company would be able to sustain and have longevity, because I feel like the segregation in the workplace would have a very negative impact on employee morale and kind of company morale in general. I also think it would be very hard to find people to work in such an environment. And so ultimately, I think this would affect the company's bottom line and their profitability to be able to kind of operate as a business. I think it would be, especially in this day and age, I think it would be very, very detrimental to their ability to be able to sustain their business. So that is, those are my responses for Brown versus Board of Education.